So with this, I'm very happy and proud to announce Ulrich Plate here. He's a senior information security consultant with a lot of experience, and he has the chance to bring to you more information and the follow-up of his talk of last year on NIS2. Please give a warm applause to Ulrich.
Thank you so much. I hope this comes across loud and clear. Very well. Let's get started. First of all, thank you much for being here this early. And for those of you who've actually been here last year for the first part of this talk, an extra warm thank you, because it's been dull already and you came back nonetheless. So there's a good chance that you might even enjoy, or whatever you call enjoyment in this particular case. We're going to talk about the NIS2 in its particular form that's been coming up for the past few months only. You know that this has been already in place in the European Union since January 2023. The Network Information Security Directive of the European Commission. That, because it's a directive, has to be implemented individually in each member state. And since July this year, we've had a draft of the Implementing Act. What that is and how it works, I'm going to be talking about throughout this roughly 28 minutes and 47 seconds talk. And there's a lot to be said about what's going on behind the curtains. That's going to hit you in the first few minutes, and then we're going into the more concrete details that this looks at. There's just one implementing act. The title in the announcement said it was implementing acts. It's actually an act and its annex, which is the longer part of the document. But the important thing is that they're both extending the regulation that is contained in the NIS2 for all sectors to a defined group of digital services providers. So there's a limitation as to who this applies to, and it has two sides. It looks at the significant incidents and what are the criteria to make an incident significant, and it has a 27 pages document that has all the cybersecurity risk management measures that are already defined in the directive, and a little more concrete, a little more precise in the act. The directive does not preclude an implementing act for other sectors as well. So the digital services are regulated right now. There is the possibility, and it may well be that this will come over time, that other sectors are going to be hit with something that is similar to it with regard to essential and important entities. That's in the recital in the directive. It's already mentioned, and so it may happen at any time. So see if this works as well. It does. Wonderful. Now this second Network Information Service Directive was adopted last year and is being implemented in the EU member states, who have all but 5 of them out of 27 missed the deadline. That was set for last month, 17th October. Only a few have made it until then. Germany would have stood a chance of implementing it by at least spring next year. So in March 2025, we were supposed to be ready to have it up and running. Now we have this mishap of the untimely dissolution of Parliament now, and things are very unclear if this goes through Parliament before the dissolution or will land in what we call discontinuity and has to be set up again for the next legislature. The term runs out so in February, and if anything can be done before Christmas, that's good. If not, we're looking at a postponement of at least a year. So don't expect Germany to be ready before November 2025 to have this implemented. Now, we're in good company. There are other countries who haven't even set up a draft legislation for this, so we're not that far behind. But at some point, the European Commission will be fed up enough to start infringement penalties, and those, if you've seen them before, are costly. They are in the region of €1 million per day of each day that you're behind schedule, so that would be really, really hard to bear. This is the current situation. So the transposition status for the directive in each individual member states looks like this. The red ones are those who haven't even come up with a draft so far. France is particularly difficult because they have a mix of laws where even defense law is combined into protection of critical infrastructures, and they have enormous trouble of getting these legacy regulation into the new laws. That's why they haven't even done a preliminary draft for this. The green ones are those who've actually made it in time. Italy just a week before the deadline ran out. The others are Belgium and Latvia and Croatia and Hungary, which is a special case we're going to talk about. Because there's a few particularities to the transposition of directives into the national laws. The one rule that stands out when it comes to transposing EU directives is that you mustn't fall behind the level of regulation in the directive. So countries can I mean, you can't lower the thresholds, but you can go above them. If a requirement is applicable to all sectors, the national legislature can add features like more severe rules or extend the scope. As in the case of Italy, they added an additional sector that wasn't entirely included in the directive before. But the more or less these more severe rules are possible. You can't fall behind that was what was already included in the directive. So there's a threshold that you need to stand above. So in all fairness, there is no European harmonization in this worth talking about. Every draft I know of and every national law I've seen are in some respects different enough to be able to have a very close look at it and be confused as to what they actually want. The German law, for example, the draft that has been discussed here, has a particular aspect for, you know about the essential entities at the top of the food chain and the important entities. Those are the ones that are regulated under the NIS2. Now, Germany has inside the essential entities another group, which is the former critical infrastructure providers. And they still have an exception when it comes to intrusion detection systems. So there's a passage in the law that wants critical infrastructure providers to have a setup that includes intrusion detection. I don't know of any other examples in other countries who do this, but this is what's happening here. Critical infrastructure providers are everybody who's above a virtual threshold of 500,000 inhabitants that would be hit by a failure in their services. And that translates to individually very different numbers, like 3.5 megawatt of total power in data centers, for example, or 300 autonomous systems for internet exchange points, and that sort of calculation that would be different for each sector. So telco subscribers, the figure would be 100,000. You'd be a critical infrastructure provider if you're above that. So now, Hungary is interesting because not only were they the first ones to actually adopt this, but they also had a very, very different approach. They've not only had very severe deadlines for registration. Companies in Hungary had to be ready. The law was implemented by the 24th of June or something, and a week later, all companies had to register. All those who would be implied in the regulation had to be registered at the authorities. Then they had time until the official deadline of the directive, the 17th of October, to implement a 120-page document that the Hungarians came up with themselves, with technical and methodological instructions that they deemed interesting and compulsory. And now they're in the stage where they have to, and this is unheard of in the rest of Europe, they have compulsory certifications. So they need to get a contract with an auditor until the end of this year. And by the end of next year, they have to be ready, certified and audited and proving this to their own authorities. Yeah? So, I mean, this compared to Germany, for example, there's no legal obligation to provide proof that you've implemented the measures here. There is the mandatory documentation that everybody has to have, but no automatic process of handing this over to an authority. Only if they ask you for it, you are in a position to produce this. Whereas in Hungary, everybody needs to make clear that they've certified and met those very short deadlines as well. So the other thing that is different between the digital services and the other sectors, which is why we're looking at the Implementing Act here, is that there are a number of highly supercritical industries that are considered so important that even if you're a one-person shop that has a domain name resolvers or a top-level domain registry, or even, I mean, that's probably not a very small company who does that, but qualified trust providers. Those three are considered essential entities, so the top of the regulated institutions. Even if they're very, very small. For everything else, you have this size cap rule. I explained that last year already. So if you're above a certain size of the company, you're almost always an essential entity if you're in the respective sectors. This is true for also non-digital services. But there are exceptions to the rules, like the trust service providers, who are also under regulation if they're smaller companies, not as severe as the smallest ones, in resolvers and things like that. And for public telecommunication services and publicly available communication services, i.e. ISPs, they are even at a smaller size, the 50 employees, still in the essential entities category. That is a non-exhaustive list here. We have several others who may or may not be aware that they're intended to be regulated under the directive, like managed service providers, managed security service providers. Those are new categories that have come into regulation and hadn't existed before. We still get calls from very confused people who think that is outrageous that they're now under the scope of this regulation, but that's how it is. For these digital services, there are two ways of governing them as it comes to territoriality. For telecommunication companies, the general rule is they are under the jurisdiction of each member state in which they provide services. So for a company that's operating in all of Europe, they have to register with each authority in each of the countries, and they have to report significant incidents to each individual institution there. Whereas the others, like data center providers who work cross borders, and content delivery networks, the managed service providers, everybody else who is represented in more than one country. The idea is that you have one main establishment in the European Union which is responsible for governing all the others, and you register only in one country, and from there everything else is being done then. What is the main establishment? It's according to the directive, that's where the decisions related to cybersecurity risk management are taken. if that's too difficult to decide where you have your upper management that does that, it's the country where you have the most employees, to make it simple. It may become very complicated in the case for a company like, for example, Deutsche Telekom, who's obviously present in every single country. They have a task force at their security branch. The Deutsche Telekom Security has dozens of people who look at over 300 companies that they own throughout Europe to check whether they're compliant already according to the local laws and the overall European rule. That's a lot of work to get this done. So just as an example, how do you go about registering and fulfilling your obligation to report significant incidents? Well, you look at your company structure and you have a main establishment. So if your data center is in Munich and has a failure, a critical one, but your headquarters is located in Rotterdam, you'll have to call them, tell them what's happening. They report to the Dutch authorities. And if it's heavy enough, what's going down, they might in turn contact the BSI, the Federal Office for Information Security in Germany, and tell them what's happening. So it's a little bit roundabout, but that's how it is in these particular cases. Again, for telcos, that's not your worry. You do it locally wherever you are in the country. So this is... who's been here last year knows the content of this slide. These are the 10 bullet points that are included in the directive, which lay out the cybersecurity risk management measures that need to be taken to be compliant with the directive. So, and as broadly defined as this is, the important part is documentation and proof of implementation. So this is what you have to do, even if nobody asks you in any time soon, whether you have this ready or not. But you better have this in a drawer somewhere when the occasion arises, which will regularly be the case when you have a major incident and the authority asks how this could possibly have happened, because you've been compliant with everything, and so they will want to know if and how this came about. If an incident has raised doubts whether you've actually implemented those measures, this can become very costly, in fact. The fines that it can put you under are hefty. And now, I mean, looking at this list, I'm not going through with it with you because we don't have time for this, and it's not necessary anyway, because you might already consider all of this best practice, and you've been doing this for years. So there's nothing astonishing in there. There's no new obligation that you've never heard about, but it's becoming compulsory. And the compliance with all these compulsory rules is becoming a business tool. So if you provide services to customers who are under the rule themselves, for example, they have to make sure that you're able to fulfill all these duties before they can make a contract with you. Because their own risk management needs to make sure that you are complying with the same rules they've been put under as well. Now, there's on top of this 10 bullet point list, there's now this Implementing Act by the Commission. The Commission does this whenever they feel that there's a need for a legally binding act that enables the Commission to apply the law uniformly across the Union. That's when they do it. And they did this right on time, published on the 17th of October, so on the same day as the deadline for the directive itself. And while they met the term, everybody else was thinking, well, Douglas Adams has said, I love deadlines, I like the whooshing sound they make as they fly by, and let's see what happens if we don't actually make it. The implementing regulation lays down rules for the application of the direction with regards to the technical and methodological requirements of cybersecurity risk management measures on the one side, and further specification of the cases where an incident becomes significant in a way. So all this applied to the digital services, as said before. Now we have with this one part, which is in Article 2 of the Implementing Act, but then set out in the annex document. That's talking about the specific requirements. And the other one is Article 3 and following about the trigger levels for when you have to notify the authorities about an incident that has happened that is to be considered significant. We'll see what that is in a second. Now, the reason why they're doing this is because they're taking account for these industries, the digital services, of their cross-border nature. So they consider digital services to be something that is really something that needs a high degree of harmonization at the union level. And those implementing acts, they hardly ever attract attention at all. I mean, most are just a few figures or terminology specifications or whatever, and nobody ever looks at it twice. In the case of the Implementing Act for NIS2, they had over 170 statements of companies and trade associations and NGOs, largely because so much of its content was highly controversial. And so this is one of the rare cases where lawmakers actively determine technical measures. And of course, that calls everybody up who thinks otherwise what that is. Very, very briefly, because we don't have a lot of time to dwell on this. That is the possible causes for significant incidents that are included in the implementing. You have the general rules, like for €500,000 or 5% of your company's annual turnover is being jeopardized. Whichever is lower, you've have had exfiltration of trade secrets or any other things that apply to everyone. And then you have the industry-specific reasons, the criteria like the average response time for a recursive resolver is more than 10 seconds, for example, or 1 hour or more of limited availability of data center services and stuff. It's mostly these criteria that have made reason for, protest at the Commission level when it came to the Implementing Act. The other part, the one that's basically in the annex, is the technical and methodological measures that need to be taken to be compliant with this. What's more clearly stated in here than in the directive itself is the policies. There's an overarching policy that needs to be set and documented and approved by top-level management and everything. That's on the security of network information system, and that rules a number of topic-specific policies that are all listed here, and in the directive, not in the directive, but in the Implementing Act. And they need to show the intention and direction on a specific subject as approved by the appropriate level of management in itself. So that's also very clearly put. And this is very, very new. It came up still in a draft stage. The European Union Agency for Cybersecurity, ENISA, has drafted a document that has an impressive number of pages, even more than the Hungarians came up with, that has step-by-step interpretation of the technical rules that are set out in the Implementing Act. They explain it. They take each requirement and add 4 types of information to it, guidance, examples of evidence, which are very important if you want to prove that you've implemented those things, whatever they call tips, handy new ideas of going about things. And very important, I'll show you that in a second, the mappings to standards. So we're on the last 5 minutes of this presentation anyway. So this is the structure of the document. You have, for each requirement in the Implementing Act, you have subpoints that are being taken up by the guidance document. They have made clear that what they repeat for readability, so the requirements from the Implementing Act are all of them mandatory and must be implemented in their entirety. Now, I've been discussing this morning already. It's very unclear how they will go about checking whether it's exactly what they've asked you to do that you've implemented. There's no way to measure this in any way. So there's going to be a lot of variations on interpretation of this. Nevertheless, this document has, for each of the 13 chapters in the annex, a requirement list that is commented and interpreted and helpfully added to in this way. This is what it looks like in the draft. I've taken the simplest one that fits on one slide. So you have the blue part is what comes from the Implementing Act, and the red is the guidance. The whatever color that is, I'd call it apricot, maybe, is what you could provide in terms of documentation, of evidence to auditors and stuff to comply with this. And last but not least, this is what I really wanted to show you, the mapping table. Now, what they've done is they take European international frameworks, and they've cross-referenced everything that's in the Implementing Act and their own guidance document towards the different rules and entry points in the standard. So you have, on the higher level, you have the ISO 27001, you have the NIS2 cybersecurity framework, the ETSI standard, and the technical specification of the CEN. That's on the international side, and then on top of those you have a number of national frameworks that are also included in this document. They shouldn't be interpreted as a measure of equivalency among the different standards. That's not what's intended here. What they do is they refer to relevant requirements in these standards without assessing whether they fully cover the regulations requirements, but the idea is to make you understand the underlying intention. So if you have a certification for one of these standards already in the company, you may well be able to cross-reference it to the regulation that you're encountering. And we're on the last few seconds of this bit. There's 3 things that you need to take away from this, and I hope I haven't bored you too much to be able to actually take this. You'll have to be ready very soon. There's the transposition that's particularly slow in Germany for the reasons I told you before, but other countries will be ready by spring next year, and they will apply this, and it's going to be mandatory for everyone. So you better be prepared wherever you are located. It's going to happen in Europe, and not just for European companies, for everybody who's active here. This will be here. The implementing guidance that I've shown you, there's a open consultation period that's ending on the 9th of December. Until then, you can upload comments to that and look at the document in a way that makes probably it's just a few amendments to it, but it's already an excellent tool if you want to achieve the goal of being ready in time, because it's not exhaustive, but if you do what's inside, that's probably all you need to be able to be ready. And have to keep in mind at the same time that there are different rules in each country that are going to be applied. You have to look at it. They are similar but not entirely covering each other, and check the national specifics of each of the member states. If you're active in more than one country, compliance is something that is not entirely identical everywhere you want to go. And with that, I leave you here with another minute to go for questions.
Thank you, Ulrich, for these insights into this topic. And yeah, I think we have time for 1 or 2 questions. We also take questions from venueless. Okay, I'll bring you the phone.
Yeah, thank you for the talk. Karim Geiger from OCOST. We have our headquarters in one European country, hosting services in the other, and customers from yet another. Where exactly do we need to be compliant? Everywhere, or where our headquarters is?
No, the compliance has to be assured everywhere you are. The question is, where do you need to register? If you're one of those where the main establishment is the decisive factor, you have to be registered in only one country. But the compliance applies, of course, to all of the branches that you have, no matter where they are located.
We have time for one more question. No? Venueless also? Then thank you very much, Ulrich. Please.
Thank you for having me.
Thank Ulrich with a warm applause.